second felony offender. Offense: indecent behavior with sentencing date June 19, 2018. Sentence a total of 7 years and 6 months. Parole date is March 11th, 2022. Good time, not eligible. Full term is December 11, 2025. Is this information correct?
Yes, ma'am.
Thank you. Mr. Roche.
Thank you, Ms. Teresa. Good afternoon, Mr. Shelton. How are you?
I'm good.
Good, Mr. Shelton, you're currently 65 years old, is that correct?
That's correct, sir.
And you are a second felony offender. What was your first conviction?
First,
Your
I didn't
second,
have a first conviction.
okay.
This-
Possession of crack cocaine, maybe?
No, sir.
You pled guilty on February 7th, 2007 to the offense of possession of crack cocaine in Wynn Parish. Is that not correct?
Oh, that's correct, but I don't know whether crack cocaine or not.
That's what your rap sheet says.
Yes, sir.
And you were terminated on your supervision unsatisfactory on June 19th, 2018. Okay, let's go. So you're a second felony offender, am I correct?
Yes, sir.
Okay. And you were 60 years old at the time of this offense, right?
Yes, sir.
How old were you? How old was your victim?
Four.
Yep, exactly right. She was 4 years old. An age where she didn't know what was happening. And you're a person of trust, so she didn't resist because she didn't know exactly what you were doing to her. Now tell me about the programs you've completed.
I've done living in balance, reentry pre-release, and cage of rage.
Okay, so you never got to the crux of your problem. Why did you refuse to enroll in sex offender treatment?
I'm in that one now, sir. I'm in that one now.
Why did you refuse to enroll at the time they requested that you enroll in it the first time?
This is the first time I'm knowing about it.
Well,
Last week of September.
on your annual assessment, and let me get to that page. That's on page 27. Question number 22. Sex offender treatment indicated yes. Question 22A is checked off, refused treatment. And that was done in May of 2021. When did you enroll in sex offender treatment?
September, the last week of September 21.
So basically, 5 months after you refused to enroll, you decided it would be best to enroll.
I wasn't told about it back in May.
Okay, well, the information is wrong because it specifically says that you refused to enroll. So basically, you found out that you were up for a parole hearing in September, so you decided you think you might want to enroll. Pretty much the way it happened?
No, sir, that's when I was brought the papers to sign
Okay.
last week of September.
Okay, great. Now, I want to inform you, Mr. Skelton, that you have a poor supervision history. You've been revoked on occasions, and then you finished unsatisfactorily. The victim's family is adamantly opposed to your release. The DA office has submitted a statement saying that he is opposed, and the judge strongly opposes. And if I'm going to vote for you, Mr. Skelton, you must complete your sex offender treatment.
Okay, I'm working on it.
In most cases, you're in phase 1 right now. Am I correct?
Now we started phase 2.
So you're in
Phase 2 last week.
So you have phase 2 to complete, phase 3, and phase 4.
That's
So,
correct.
so you need to complete all 4 phases of the sex offender treatment, take some additional programming, because you need some other programming, and write back when you complete that program, because I need you to complete that program if I'm going to vote for you to be released.
Yes, sir.
So, especially because the victim was 4 years old and you were a grown man of 60 years old at the time this occurred.
I understand.
Okay. Mr. Chairman?
Thank you, Mr. Roche. No other questions? Is there anything, Warden, is there anything you'd like to say on behalf of Mr. Shelton?
Not really. He's, like I said, he's been disciplinary wise, been good here. During my interview with him, prior to the hearing, this lack of, emotion with this kind of concerns me. I will make that statement on there. It does concern me on that issue, but as far as within the facility, he has been staying out of trouble.
Okay. Thank you very much. Is the panel ready to vote? Mr. Shelton, is there anything you'd like to say before the panel votes?
Your Honor, I just want to be paroled and do my appeal with my hearing that I'm on with the federal court.
Okay.
That's why I want to proceed in.
All right. Thank you, Mr. Shelton.
Thank you,
Mr.
sir.
Roche, you ready to vote?
Yes, I am, Mr. Mirabella.
Okay.
Mr. Skelton, based upon very strong law enforcement opposition from the DA's office, the victim's family is adamantly opposed, and in lack of rehabilitative programming, no sex offender treatment, my vote is to deny your request.
Thank you, Mr. Roche. Ms. Wise?
Mr. Shelton, my vote is the same for the same reasons. I'm glad that you're in class. Please sit on the front row and really get some insight, as to your offense and how it impacts your victim and your community. Best wishes to you, sir.
Thank you.
Mr. Shelton, you have 2 votes to deny your parole. I'm going to deny your parole for the same reasons as outlined by my colleagues. I'm going to encourage you to continue to work hard, and perhaps next time you may be in a different position. But for today's vote, your vote has been denied. So good luck to you, sir.
Thank you, sir.
All right, that's it.
Well, that's the sentence that they give in the state of Louisiana. When you're 60 years old and you plead guilty to doing that to a 4-year-old, and they give a little slap on the wrist sentence, you can't make it up. 7-year, 6-month sentence, and he has the possibility of parole after serving, I think it was just 4 years. This hearing was in 2021. He was charged on April 29th of 2016. He was denied, thankfully, and I'm happy to share with you that he is still locked up. But he does have his good time date in just a couple of years. Today, he's 67. He'll be under 70 when he gets out, or 70. And does he give you any confidence that he's not going to do this again? You don't just go and do that to a 4-year-old, and it's the first time that you do it when you're 60. How many child's lives has he ruined? And how many more will he ruin? Now, in the court, in his appeal, he took an Alfred plea. And then after he was sentenced, he appealed and said, he did an Alfred plea. And then on the day of the sentencing, he went to withdraw his Alfred plea, said that he had insufficient counsel, or ineffective counsel. And they refused to let him withdraw his Alfred plea. I'm sure most of you familiar with the Alfred plea. It's where you take a plea. It's the strangest plea deal. It's where you're not admitting guilt. You're not like denying guilt. You're basically saying that the state has enough evidence to say you're guilty. So you're just going for the plea. I wonder what evidence they had. I'm guessing a confession or something. It doesn't seem like they don't go into that. All it says here is that on April 29, 2016, he was charged by a bill of information with 1 count. That's all they charged him. 1 count. I never understand why they just do 1 count. He was represented by the Office of Public Defender on April 18, 2018, the state of Louisiana, the state of okay. 1 count of indecent behavior with the juvenile. The date of the offense was also amended from March 21st, 2016 to March 25th. It's like they have a specific day. Maybe someone walked in. Maybe, it's not, it doesn't have more information than this. He answered, here's it goes into answered the Alfred plea in his best interest in exchange for a reduced sentence. Exposure of 7.5 years. It doesn't give any more information than that, other than that they rejected his appeal. And it's really telling. This warden, my favorite warden, he has no poker face. He's like just looking at him like, are you kidding me? And when he tells the board that it's concerning to him that he's showing no emotion, this warden doesn't use his words lightly. Everything he says is quite, he's very aware of the effect that it can have on the outcome of the hearing. And it's just the idea that this man will get out in a couple of years is terrifying. Had he gone in for possession with intent to distribute, had he robbed a bank, stolen a car, he could be facing much more time. But he's just 4 years old. 4 years old. And the idea that an assistant DA doesn't show up, again, it speaks volumes. You always see they like to issue press releases how they are tough on crime, protect the children, but anyways, thank you, Richard, for the information. And with that, I'll let you go.